Hi everyone, thank you so much for tuning in. I think this is the very first webinar I've ever done, so you're going to have to forgive any awkward technological hiccups on my part. But I'd like to thank just generally Community Living Ethics and Ensemble for having me down to do this three-part session. A couple of things before we get started. Today's session, as you know, is generally about education advocacy, but a lot of it's going to be a review of some of the legal tools that you can use to realize a more inclusive education, a more inclusive education placement. Excuse me, sorry. Some of the other sessions will focus on some other things, and so I won't be covering everything today. A couple other things. I think we have some time set aside for some questions. Please feel free to ask those, although I'd emphasize I really can't address personal situations. I can't provide you with legal advice in this sort of setting. So if you could try to keep them general. Just try to keep them general questions without divulging any personal circumstances. I believe this is being recorded as well, so we don't want maybe some more personal circumstances enshrined on the internet for posterity. That being said, if you do have or in need of legal advice and you do want to talk something through, Arch has a summary advice service, so you can actually just give us a call and set up an appointment with a lawyer, and a lawyer can sit down and talk through some things to you and basically work through and talk to you about some next steps that you could potentially take to advance your arguments. So why don't we just get started? I'm going to tell you, oh, that doesn't work. I'm going to tell you just a little bit about Arch first. So Arch is a specialty legal clinic specializing in disability law. We've been around for a little while. We're actually the only one in Canada that sort of focuses in on this sort of stuff. You can see our website there, and I encourage you to visit it to familiarize yourself with what we do. We also have a newsletter that we actually send out on sort of developments in disability law, so I'd encourage you to sign up for that as well. You can see just a general list of some of our services. As I mentioned, summary advice is a big service that we really push. It really is a good opportunity to just chat through some of the legal implications of a given situation. We can provide you with some general information and advice. In rare circumstances, we do represent people as well, but typically only when there's a systemic aspect of the litigation. That is, the litigation has the potential to change the law in some positive way. And then we do a lot of law reform work and policy work, submissions to government and that sort of thing to try to help shape the law. And then we do public legal education, which we're all involved in right now. For everything but summary advice services, we have financial eligibility criteria. I should say, actually, for representation, we have financial eligibility criteria. So, you have to be under a certain level of income in order for us to represent you, but there's no requirements for summary advice, so anybody can call. So that's just, I'm actually going to speed through some of these things because I actually think I was a little optimistic in the amount of slides I could cover in about an hour. So this is just a list of some of the things that we specialize in and we could provide you with summary advice on. We're not general practitioners, so we can't advise on something like a criminal law matter, but if you have a human rights issue, an education law issue, by all means you should give us a call. Our website has a little bit more information about that. I'm just going to skip this one. So, as I mentioned, I'm going to talk just generally about some of the tools that exist in the law for achieving an inclusive vision for your child's education. Now, a lot of the things I'm going to talk about have much broader implications. They're used in a lot of other situations, and so When I talk about inclusion in these circumstances, I'm really using it as an illustration of how some of these legal tools can be used. Some of them are specific to the issue of inclusion, but others, speak more broadly to a number of other issues related to human rights. So what I'm going to do is just talk to you briefly about the Education Act, and then we'll talk about the Human Rights Code and some other just like little legal oddities that exist. So the big thing that I would really emphasize, I think, at the outset of this presentation is that the legislation surrounding education in Ontario is really old, especially things related to delivery of quote-unquote special education services. A lot of this was developed in the late 70s to early 1980s, at a time when, our understanding of disability was quite different. So things like the Identification, Placement, and Review Committee model, I guess you would call it, is really old. It's really old. For those of you who don't know, Identification, Placement, and Review Committee, I'm sure many of you do, but I think it's important to go over, is just the mechanism through which schools identify students as having a disability and then basically choose where they go within the education system to get what they need. But as I say, it's a very antiquated system that was developed at a time when our understanding of disability was not quite as advanced as it is now, and there's a few weird policy implications of that, and implications for your own advocacy and for the way we think about special education services. So as I mentioned, Bill 82, which brought in mandatory special education across Ontario, created these IPRCs, or Identification, Placement, and Review Committees. And in doing that, they brought in this process that's really focused on where a student should go in from sort of a menu of different programs that are available, rather than, a student needs to succeed in the regular classroom. The IPRC has a really limited ability to say, this is the setting where students should go with these resources. It can tell parents, it can tell everyone, this is the setting we feel a student should be in, but it has very limited ability to make decisions about the resources needed to support a student. So again, that's sort of, the focus is on where a student should go, and not what the student needs in a classroom. I'm being a little bit glib about this, just to make this as simple as possible, but that's sort of the drift in a lot of the legislation, and I'm just trying to think about how to put this. It's sort of emblematic of a lot of the older policies that are sort of premised on segregation in the education system. And you'll find, as an advocate fighting for inclusion, and I'm assuming that's what you're doing, you'll be the one sort of fighting this sort of policy drift. And one of the ways this comes up, and we often get calls from parents about this, is that schools will often say to a parent, they really have to go to this segregated setting rather than the regular classroom, because that's the only place that the supports are available to them. And so I'm going to talk just a little bit as we get through about that sort of argument from the school board's perspective. But suffice to say, I just want to emphasize that it's largely rooted in the legislative framework. So as I mentioned, we'll be discussing the Education Act and the Ontario Human Rights Code as probably some of the more relevant pieces of legislation that is important to know when you're doing a lot of education advocacy. But one of the other things that we always like to throw in there is the Convention on the Rights of Persons with Disabilities, which is a piece of international law that has limited force in Canada, but it does sort of suggest that Canada has committed to a more inclusive approach in education, and there's an obligation on all levels of government to sort of work to realize this commitment. Now, to get into sort of the nitty-gritty of the Education Act itself, the Education Act is largely neutral on the types of services and supports or that it will provide a student being educated. And it's also neutral on where students should go, how they should be educated. There's not a whole lot of enforceable rights within the Education Act. The Education Act is really about process. It says, or sort of lays out for school boards, this is how you should provide education services. This is how you figure out where a student should be placed. It says, okay, IPRC, that's how we do this. These are all the procedures. But again, it doesn't say, a student is entitled to this. Now, to sort of contradict myself just a little bit, the Education Act does say that students are entitled to go to school, and it does say that they're entitled to a, quote, appropriate education, but it doesn't really define what appropriate means in any given circumstance. So again, you can see that sort of neutrality in the Education Act, which, there may be some policy reasons for that. It is sort of difficult for the government to pass down on high, like what education should be across the province. But that being said, it leaves advocates with sort of a dearth of tools which they can use to advocate for inclusion. So the proviso to that, though, is that there have been just a couple little developments in the Education Act since the 1980s, which have pushed a little bit in the direction of inclusion, just a little bit. One of the big ones, and the one I'll talk about today, is Section 17 of the IPRC regulations. So regulations are sort of made under the Education Act and have the force of law. And this one deals with identification, placement, and review committee proceedings. So for any parents who are sitting down in one of these meetings and they want an inclusive placement for their child, it's important to know that this section basically says to a school board that before you consider a placement that is segregated, you must first consider whether a placement in a regular classroom with the appropriate special education services would meet that student's needs. Does somebody have their microphone on? All right, sorry. So I'm going to start over that. Section 17 essentially says, before IPRC committee can say, we're going to put you in a segregated environment, they really need to consider that placement in the regular classroom and whether it would meet the student's needs and whether it's consistent with a parental preference. So if you can put a student in a regular classroom and if that's what the parents want, and with the appropriate support, then it's basically says then the committee has to make that placement. There's no other option. Now, I say that section is of limited use in an IPRC meeting because it's been gutted a little bit by the courts. The courts have sort of ruled on this provision and sort of said, it's really about it's like a decision tree. It's, the committee must consider this first, and then they can basically do what they want. It doesn't establish a presumption that a student should be in a regular classroom. just a rule of general application and only in exceptional circumstances or you put in a segregated environment. It really is just like you need to consider that inclusive placement first. So that, in a nutshell, is the big, I guess, lever in the Education Act that really, it would be really useful, I guess, in advocating for more inclusive placement for a student in the classroom. The really, really, I think, useful piece of legislation, and again, we're going to do sort of a general review of this, is the Human Rights Code. Now, the Human Rights Code is a broad piece of legislation that applies to a number of different social areas like housing and employment and all sorts of different services in the province. Education, obviously, being one of those services. And the goal of the Human Rights Code is to basically create an inclusive school culture and ensure equal access to education. The goal is to prevent discrimination and ensure that students with disabilities or any other students who are recognized under the Human Rights Code have this equal access and are not discriminated against. The thing to remember about the Human Rights Code is that it is a quasi-constitutional piece of legislation. So what that means is it is of paramount importance. If you are looking at a conflict between the Education Act and the Human Rights Code wins, basically. That is what people have to pay attention to is their obligations under the Human Rights Code. Now, the quasi-constitutional nature of this legislation can be circumvented in certain circumstances when a piece of legislation specifically says, the Human Rights Code doesn't apply here, but those are such limited circumstances. And even then, it's always a little bit fuzzy as to what happens. So the important thing, again, to remember is that this is the overriding consideration for school boards when they're providing these sort of education services. This piece of legislation is sort of where a lot of the enforceable rights in the education system comes from. The Education Act, as I mentioned earlier, largely focuses on processes and how schools do things, but doesn't really guarantee anything. But the Human Rights Code does sort of sit down and say, well, yeah, no, there are things that you have to provide, and that is usually the leverage that I personally use in my own advocacy when I'm advocating for clients. It's rarely are we talking about or solely about the Education Act. We're often talking about obligations under the Human Rights Code. So as I mentioned, or maybe I didn't mention explicitly, but the Human Rights Code guarantees that students with disabilities are free from discrimination and harassment regardless of their disability. And it applies to educational services. The one thing to always remember about the Human Rights Code is you can't sit on your rights. Not that many parents do. Many parents that I've spoken with are quite engaged, but there is if you're considering legal action, which we don't always recommend, what we normally suggest is that you act relatively quickly, because there's a 1-year time limit to make an application to the Human Rights Tribunal. Again, not something we always recommend. So I guess now I'm going to talk just very briefly about what the Human Rights Code says. Now, the Human Rights Code basically, as I mentioned, prohibits discrimination, and that sort of prompts us to ask, what is discrimination? And the simplest definition that I can come up with for you is basically involves 3 things. The first is discrimination involves usually what's called a protected ground. So in this case, discrimination would require that somebody would have a disability. So that's one thing that this is the test. So the legal test asks: A, does the person have a disability? B, it asks, had something bad happen to that person? So the person has a disability, something bad happened to them. You've met the first two pieces, the legal test of discrimination. The third piece, and usually the most important, is that their disability was a factor in that bad thing happening to them. So the bad thing somehow was a result of that disability in some way, shape, or form. That's basically what discrimination is. Now, that's actually kind of hard to apply sometimes in the education setting, and we often have to think really hard about what this means for certain education cases. To the point where what I would say, or what I would recommend to everybody listening, is that the important thing to remember in discrimination cases is that discrimination in schools usually occurs in the form of a failure to accommodate somebody's disability. That is, a student with a disability, requires meaningful access to education, and often they can't achieve that access without certain supports. So a school is required to provide those accommodations in order to ensure that they are not discriminating against somebody. And I don't think I stated that in the most simple terms, but so maybe I'll say it again. So basically, the Human Rights Code requires equal access to education, and if accommodations are required to get that equal access, then they have an obligation to provide those. That's normally the way discrimination shows up in the school system. Now, the Supreme Court has actually dealt with this very issue in a case coming out of British Columbia called Moore v. British Columbia. In that case, essentially ruled that school boards are required to give students meaningful access to education as part of their obligation not to discriminate. Now, what that essentially means and what that sort of added to the jurisprudence was the idea that a student really you can't just admit a student to school and have them sit in the corner and that's consider that equal access. That's not equal access. The Supreme Court basically said, no, students need to have meaningful access to their education. They need to be engaged in their education. They need to be obtaining the benefits that society purports education to have. They need to be able to just basically get in there and engage and not just sort of sit in the corner, or whatever a school board may or may not be doing. And so as part of guaranteeing that meaningful access, the Supreme Court again reiterated that individualized accommodation would often be required for students with disabilities to actually achieve this sort of meaningful access. And what meaningful access would mean from student to student might be different, but that is sort of the standard. Now, again, the Supreme Court acknowledged, as most human rights legislation has across Canada, they acknowledge that there is this defense on the part of school boards called undue hardship. That is, school boards must ensure students have meaningful access to education by providing appropriate accommodations up to the point of where providing these accommodations would impose undue hardship on those students. And I'm going to get to undue hardship in a little bit. But suffice to say, I think for now, all you need to know is that undue hardship is a difficult standard to meet. Wait, I'm just going to switch that. Okay. So what is the question sort of becomes, what does this mean for inclusion? How do you actually take all of this and turn it into an argument or use it for advocacy? And just as an example, and as I mentioned, inclusion, can sort of be fit into this legal framework. You sort of start from the idea when you're talking about inclusion that students in segregated settings may not have access to certain pieces of the educational experience and certain, valuable pieces of the educational experience, like socialization and certain academic opportunities and extracurriculars. And, if you can call those pieces, those aspects of if you can call those aspects of education, crucial as part of the actual service of education, and there's a lot of case law that suggests that you can, then, there's a really good human rights argument to say that that is part of meaningful access. That inclusion and the benefits that come from inclusion are part of what it means to give a student with a disability meaningful access to education. And that if a school, and to get back to my earlier example, if a school is saying to a parent that, they need to go to a segregated setting because, that's where these resources are available that they need, but they admit, they're going to be missing out on some of these other opportunities, which if those supports were delivered in the regular classroom, they could benefit from, then that's not okay from a human rights perspective. So when you apply the Human Rights Code and the idea of meaningful access, what it sort of means for school boards is, yeah, you can't just pick and choose the type of benefits that a student is going to get. You can't say, oh, the supports are, provided over here, and that's what they need this for this, but, it's fine if they miss out on all these other things. Now, this is all very well and good, in theory. This is sort of what the law, I think, would say about this, but, when we're litigating these things, often proving, factually what a student needs and what they're missing out on is often very difficult. So it's often difficult to realize the promise of human rights legislation. But it's important to know that it is there. The legal framework is there to make that argument. And if you're diligent about, marshaling the evidence and marshaling the resources that you have, then you can often create quite a powerful incentive for school boards to work with you and work towards a more inclusive placement. This is just a previous Supreme Court decision, Eaton, which did suggest in some ways that that inclusion should be a norm of general application. Although, and take that for what you will, like it's the saying is in there. Although Eaton, was not a uniformly positive decision, so it's just important to know that that's there. This is always the thing I get a lot of questions about, and I hope everybody's following. And I realize this is sort of a difficult format in some ways, so I can't get your reactions, but I'm going to elaborate on undue hardship just a little bit, because in my experience, it's often something I get a lot of questions about. So, as I mentioned, disability accommodations must be provided up to the point of undue hardship, and that often raises some questions for parents as to, okay, well, what is that? A school often will say to me, like, oh, we don't have the budget for that, so we just can't do it. So undue hardship is a legal standard that's actually quite high. It's quite difficult to meet, and it only involves certain considerations. One is cost and outside sources of funding, which is basically the same consideration. It's just the way the legislation is written. But yeah, cost is one big factor in figuring out whether something amounts to undue hardship. The second thing is health and safety requirements. So if providing a particular accommodation in order to provide somebody with equal access to education would impose an unacceptable health and safety risk on either a student or the providers, then that may amount to undue hardship on the part of the school. And I'm going to break these down a little bit. In terms of cost, it's a little difficult to just say, $1,000 is the answer, because often these things are sort of context specific. But the Supreme Court, in several decisions, has, sort of emphasized that this is not just, a trivial cost that can trigger undue hardship. It really requires a very significant expenditure on the part of an organization. In some iterations, the Supreme Court has said things like, if the cost is so significant that it changes the nature of the organization, then that might be undue hardship. Interestingly enough, in Moore, which was a case about a child who needed access to an intensive sort of services facility. I can't remember exactly what it was called, but it was basically a whole facility designed up to help children with dyslexia. And the school board, due to budgetary cuts, shut down the facility. And in examining this issue, the Supreme Court went into this case and looked at how the school board had spent a lot of its other money, and noted things like that the school board did not shut down. Notably, things like the school board did not shut down like an outdoor education center. And in sort of examining the idea of undue hardship, they said, look, the outdoor education center is great, but this remedial sort of center where students could get proper accommodation, it was actually required for these students to even access education. So the outdoor center, which is sort of extracurricular, is great and all, but you really should have shut that down first before you denied access to education for students with disabilities. So that gives you a sense of how far the idea of undue hardship can be stretched when it's considering cost. That being said, again, that's sort of in theory what the law is saying, and it took a lot of very powerful advocacy to get the Supreme Court to say that. So, whether that's achievable for parents in their day-to-day advocacy is a different question. But the important thing to remember there is that undue hardship is a very high standard. And the provision of an EA or whatever, if it's necessary, or whatever a student needs, usually would not amount to undue hardship on a school board. Health and safety requirements is a difficult one, and it's highly context specific. There's a lot of other legislation that sort of involves these health and safety assessments. If you do ever encounter a situation where a school is saying, I can't accommodate your child because of it's undue hardship or because of various health and safety considerations, that's sort of the point where you should seek legal advice. And I would recommend you give us a call or speak to another lawyer. I would definitely, if you're in that situation, seek legal advice. So for the final thing I want to talk about with the Human Rights Code is that it sort of imposes a number of obligations on all of the parties to a student's education. The Supreme Court says, there's the duty to accommodate, but there's also this procedural duty that exists. And as part of that procedural duty, everybody really has to cooperate and get along in developing these accommodations. You can't have one party in there, sort of holding out and saying, I'm not going to cooperate in this process. And so this procedural duty to accommodate is what we call it, imposes a number of obligations on all the parties. For parents, it says basically that they have to disclose the existence of a disability to the school board. And it says they have to also provide what's, I guess the term is the necessary information. Oh, sorry, I'm just seeing the question. Okay, sorry. Yeah, and I will definitely address that in a little bit. Sorry, to get back on track here. So in terms of the procedural duty to accommodate, for parents, it says, yeah, you have to disclose the existence of a disability, and you have to provide the school board with the information they need to actually accommodate a child, which sort of makes sense. Like, you couldn't go to the Human Rights Tribunal and say, well, I didn't tell the school board my kid had a disability, and I denied them access to the information they needed, and still expect the Human Rights Tribunal to enforce your rights. The duty that it imposes on school boards is basically that they really have to consult with everyone that's necessary in developing an accommodation. They can't just sort of unilaterally impose what they think the proper accommodation is. They have to talk with parents first about what they think about the circumstances at home, and what their experience is, and how they think it might be best to accommodate their child. And they may have to consult with professionals and pay for those professionals to sort of sit down and say, okay, well, this is what I would recommend. That's not to say, though, that the school board always has to do what parents will say. The Human Rights Tribunal has been pretty clear about that. But that expertise that you parents have must be considered. So that's often a point of contention in a lot of these fights, is that, and we've actually we're about to release some research study that we've done in the next couple months that talks about the fact that a lot of school boards don't really engage that well with the sources of expertise that they have, and that's problematic from a human rights point of view. Okay, so I'm again, this is part of my ambitious slide. I'm actually not going to cover the CRPD except to say that it's there. There are these international obligations. All levels of government should be working towards sort of a more inclusive educational delivery model. But this probably won't play a big role in your day-to-day advocacy. So this is, I often get a lot of questions at various presentations about, sort of much larger problems. And I sort of spoke to those larger problems at the beginning of the session to say, like our legislative framework is old, it's not as responsive as it should be. And the reason I sort of address this is because there will be sort of a limit in terms of what your advocacy can achieve, what the Human Rights Code can achieve, what anyone can sort of achieve on an individual basis. So when you're thinking about inclusion and some of the broader, more systemic problems related to it, I think one of the important things for parents to know and a lot of people to know is that school boards have such a huge amount of discretion over the way they deliver educational services and the way they spend money. When you talk about segregated programs, you end up like pulling all sorts of money to set up these programs away from the regular classroom and sort of preclude the opportunity for a unified environment with additional services available. And that those are policy decisions at a school board level. And I've sort of laid out the educational provisions here, which I'm not sure, now that I'm thinking about it, I'm not sure you need to know what all these are. But the important thing, I think, really is probably in this slide. And it basically says that, school boards must develop a special education plan, which they must submit to the ministry. It must outline the school board's general educational and service delivery philosophy, how they intend to deliver special education services. And it provides very broad outlines of what these plans must adhere to, but it doesn't say, school boards must favor an inclusive educational system or it must favor a segregated educational system. There's a lot of flexibility built into the Education Act regarding how school boards deliver educational services, which means that there's actually a huge amount of opportunity at the local level to change the way your school system works. School board elections, I actually delivered this presentation at Kenora and had the results of the school board election there, and like you saw some trustees were elected by like 3 votes or something like that. There's a lot of opportunity for parents to sort of engage and get a group together and invite a local trustee to go speak to them before an election and to influence those local trustees in their own views about how the education system should run. These trustees technically work for all of you. So there is that opportunity there for a more systemic approach to some of these larger problems that you're never going to resolve on an individual basis. But collectively, you can get a shift in the way school boards do things. Leadership at the local school board level, I think there's actually research talking about this, but leadership at the local school board level is the biggest determinant of inclusion generally. And we have a lot of presentations from, or I've been to a lot of presentations with various experts, and in a lot of cases the problem is not always money at the local school board level. The Ministry of Education gives schools a fair bit of money. It's sometimes just the way it's used. That being said, there is a provision in the Education Act that says school boards should be promoting a more inclusive environment. But again, it's not as compelling as we'd hope, and usually implementation on the local school board level really requires a local push.
Fine, how are you?
So the last thing I think I'm going to talk about is just, and I always emphasize this, and I was talking to my executive director the other day, as I feel like at the end of every presentation I do, I always somehow discourage people from ever calling us, largely because I always say the legal system is not usually the best place to resolve these sort of issues. It's a very, very toxic way to resolve an issue. It is required in some circumstances where things have just reached the breaking point. But if I'm sitting down representing you and filing a human rights application on your behalf, it's probably gonna be 1 to 2 years before it's litigated and you have a result. And in so many cases, by the time I'm done litigating, it doesn't even matter anymore. This kid has moved on to a different school, or it's grown, things have changed, all sorts of things have happened in the intervening months, and suddenly things aren't so. What we were arguing about, a year or two ago is not so relevant anymore. So we always emphasize, the informal process can be really helpful. Really sort of pushing, marshaling the evidence, pushing school boards, being, as cooperative and polite as is possible, but taking a strong stance with the school often gets better results than the legal process. That being said, you should get legal advice in a lot of situations, and there may be breaking points where it's just you just need to go for it. So here is just a brief summary of what an application to the Ontario Human Rights Tribunal looks like. You file an application. The other side gets an opportunity to respond. Then there's an opportunity to reply. There's several sort of exchanges of documents, and then there's the opportunity to mediate. And we always recommend doing mediation because that sort of short circuits the whole process. You can get a result a little bit quicker than you otherwise might. Mediation will often lead to settlement, and then that's just it. Gives you and the school board sort of an opportunity to shape the way the legal process played out. You hopefully have a lawyer, so you have some advice, and it's usually a much better way to do it. But if it doesn't settle, even if you do mediation, it doesn't settle, then you get to the point where you're tribunal hearing, in which case that's again much more litigious. You're dragging people in front of the tribunal to testify. A lot of bad feelings there, and it can really damage the relationship beyond what a lot of parents. It's beyond bad sometimes. So here are just a couple resources for everyone. I think I've actually done pretty well in terms of time. So the Ontario Human Rights Commission publishes what we call the Accessible Education Guidelines. They're amazing. They're a little bit old now, but they are being updated as we speak. But they really give you a good sense of what some of these human rights principles look like in action. You can always call us. That's our contact there. Justice for Children and Youth. They do practice education law. They're another specialty legal clinic. They're wonderful people. Human Rights Legal Support Center is a much larger organization than ARCH and handle a lot more human rights applications than we do. They also have certain in-house expertise in education as well, and they're great. The Child Advocacy Project by Pro Bono Law Ontario, they may be a good resource as well. Oh, you know what? And I'm missing a slide. The Ontario Ombudsman is also an excellent resource to call. They may or may not address your situation. Sometimes you really do need a lawyer in certain situations, but the Ontario Ombudsman can really investigate some of the more egregious problems or violations of a child's rights, and they can do it quickly. They have the power to make recommendations to the school board and publish reports. They don't have the power to order the school board to do anything, but the recommendation that they come out with, it can be pretty powerful. So I think that's what I had for this first presentation. I hope that was informative to everyone. If you have questions, by all means. I saw one question earlier. But if anybody else has a question, I don't know how Kelly wants to run this. Kelly? Are you there? Oh, she's doing something. Yes.
Questions in chat? Does that work?
Yeah, okay, yeah. So yeah, stick your questions in the chat. I'll maybe give everybody a minute to do so if they want to. Otherwise, I can just start with the health and safety requirement question. And please feel free. I did power through this. It's a new presentation, so if there's anything I skipped a couple things, sort of based on the idea that people would probably know that, but I encourage you. I ask stupid questions all the time, so please don't let any fear get in the way. I'm more than happy to answer any general questions. Or again, you can just call us, and we're more than happy to talk to you. I'm going to wait 1 minute.
Questions that are being typed right now, so that's great, guys. Thank you.
Okay, perfect. So I'm going to start with Kelly's question just because it's the easiest. By all means, share the slides. I would share them sort of with the proviso that, the best resource, I think, is to consult with a lawyer. And we're more than happy to talk with people about it. Don't let them rely on this material, as the gospel truth, because it does require some interpretation, application, and all that sort of stuff. So by all means, share the presentation. I think this is being recorded, so people could probably access this presentation too as well. So I would encourage people to share around and get the word out. I'm sorry, we're going to the health and safety question. Where was that? So to elaborate on health and safety often comes up in the context of when there's like maybe a behavioral issue for students with disabilities. Maybe there's some aggression on the part of a student, and they may require a behavioral support plan or a safety plan to be implemented. So that's often where schools are saying, accommodating the student, putting them in the right classroom or whatever it is, not using restraints, all these things not doing these things would amount to undue hardship. The counter to that is often schools, before they make any claims about undue hardship, they really have to prove it. This can't be like a speculative, like, oh, I heard that this person has this disability, and people with this disability are often very aggressive. So, we can't accommodate that person because it'd be unsafe. No, that doesn't suffice. You can't be speculative. There has to be evidence to say, this is an identifiable concrete risk that is unacceptable. Like a little bit of risk. There's a little bit of risk getting up in the morning. So, a little bit of risk does not trigger this. undue hardship. What it is, a significant identifiable concrete risk that can't be mitigated in some way. And this is often where school boards run into problems, or at least in the cases I'll take, is that, they're claiming that a safety problem is there, but, they haven't developed any mitigation measures. They haven't developed a behavioral support plan. They haven't developed a safety plan to try to manage these things. And in those cases, we usually say to them, like, well, no, you can't say that this amounts to undue hardship. This is, you have to take some steps to try to accommodate the student properly first. So that's one example of what I'm thinking when I'm thinking about health and safety considerations. I'm just trying to think if there's anything else that I've encountered. Like, a lot of these principles are designed to be fairly broad, because we have to remember the Human Rights Code is not designed to apply to the education sector specifically. It's designed to apply to a whole lot of things. So everything in it has to have been tailored by the tribunal over the years in terms of the way it fits. So health and safety doesn't have to mean what I just said, but that's a common example in the education sector. So another question here. When looking at schools, what should I be looking for to give me a sense of whether a school would be a good fit prior to enrolling my child? Any buzzwords or That's an interesting question. It's a little bit hard for me to answer because to sort of hit back to what I was saying of the Human Rights Code, everything is so individualized. What would work for one student might not work for another. If you're interested in sort of a more inclusive setting, one of the things that you really want to try to assess is the degree to which will they actually believe in inclusion. And that's sort of an intangible question. It's very difficult to say the degree to which a school board believes in inclusion. But, in some school boards, it will be very evident. I always use the example of Avon Maitland. They've made, a significant push in the direction of inclusion. And, they are quite renowned for it now. Like, they get visitors from all over the world. I've never been there, so I don't know if that's the model, but if I were looking for my child, I'm going to say this is not legal advice, but if I were looking for my child and that's what I wanted, I would be looking at whether they have made a push to really promote inclusion, whether they've taken some concrete steps towards that, because leadership at the school board level, that's the biggest determinant of an inclusive environment. Beyond that, it's a little bit hard for me to say. I'm not an educator. I just litigate against them. So it's a little bit difficult beyond that. I hope that was a little bit helpful, at least. I see another question here. What is it? Can we get it? Okay, this is, yeah. I think I've answered that. Or Kelly did right there. If a school disagrees on the accommodations because it requires some additional supports and even rejects an IEP meeting between the parent and the teacher after initial IEP was signed, they would reject meaningful. Yeah, so there's a couple questions in here. I think the first thing I would say is probably tune into our third session, because I'm going to focus a little bit more on some of the concrete steps that you can use to advocate in an education setting. But the risk sort of giving a lot of it away. Some of these things, to risk giving a lot of it away, I would say, some of the things that you seem to describe in your questions seem to be pretty blatant problems. I mentioned earlier the procedural duty to accommodate, which sort of requires cooperation between the parties. If a parent is requesting in good faith, an IEP, a meeting about an IEP, then it's difficult for a school board to say no. They do have to have that meeting, especially if there is a significant concern. One of the things about the Education Act and the Human Rights Code is that they both require sort of a constant revision of IEPs and a constant assessment of children's progress and looking at whether accommodations are still appropriate. That's supposed to be an ongoing process. So if a school is sitting down and saying, well, like, oh yeah, you signed an IEP, but we don't want to meet with you anymore, even if you have concerns, and that's a little bit problematic. Let me just try to parse it. As for data collection in the school board, that's a little bit difficult. We often get, I had a case recently where a parent really wanted better communication with the school, a better sense of what was going on in the classroom, because they had suspicions, and reasonable suspicions, that certain things were not being done. It's very difficult to litigate communication or the quality of communication. And mostly the Human Rights Tribunal will be very reluctant to deal with something like that. The best way to push the school board to improve the level of communication is to sort of ground the need for communication in their accommodation obligations. It's basically saying to the school board, we need this information. Sorry, as an example, I'm going to use an example. We need this information in order to facilitate a child's learning. We need this information in order to ensure that proper accommodations are being provided and to ensure that a behavior plan is in place. It's very difficult for me to sort of make that point in sort of the abstract and the outside of a situation, but the idea is it's not, a school board does not have an obligation to communicate with a parent unless it's, I mean, they do in some senses, but unless a new school board, I'm going to restate this, the school board does not have an obligation to communicate with a parent outside of, the regular type of communication, unless it's really focused on this child's needs and what, and then communication is required to properly accommodate them at school. Does that make sense? Oh, sorry, she cut me off. Tired of me rambling, but hopefully that's. Oh, do we have another question coming in? Yeah, what I would say is I mean, the IEP is not really like an enforceable contract. The IEP is really just evidence of what was agreed to between the parties. Now, I think generally a school would be very reluctant to put something like that in an IEP. And unless it was grounded directly in with the needs of a child and the provision of accommodations. Like unless it was, here's a good example. I had a client a while ago who, was on the spectrum and required a consistent environment from time to time. Incidents at school really needed to be reported home to help manage the behaviors. Now, and vice versa. Like there just needed to be that line of communication to help each environment manage what was going on in the other. You can ground that requirement pretty clearly in human rights law because the accommodation, it's required for the accommodation. Outside of that, if you just sort of want to know what's going on, it's more difficult to sort of make that argument. So whether it should go in the IEP or not, it'd be great if it did, but I would believe schools would be reluctant to do that unless it was sort of grounded in the accommodation needs of a student. So I guess I'm not discouraging you from doing it, but I think it might be an uphill battle. So is that it? I think that if that's it, anybody else? I'm not seeing any other questions. So, Kelly, do you have anything else you wanted to?
I don't think so, Luke. I think that looks like everyone's questions. Did anyone else have any other questions before we sign off for the night? You can type them now. If not, I think we will say thank you so much to Luke and Arch Disability Law Center for doing this tonight. We appreciate this, and thank you for everyone's patience. We had a few technical issues at the beginning, so I hope you found this very helpful and that you can join us again in 2 weeks.
So what I'd say as well is that if anybody has any questions, again, please give us a call. Any feedback as well for me in terms of the presentation is more than welcome as well. So please be my guest, and I hope I will hear from a lot of you in the next 2 weeks.